Ready? Start. We have heard the learned counsel for the parties at length and with their assistance, we have also gone through the records of the case. Stop. We have also perused the evidence on record. Stop. On giving due consideration to the material on record, we find that the prosecution failed to establish its case against accused persons beyond reasonable doubt. Stop. The complaint was submitted after 3 months of the occurrence of the alleged incident, and in the meantime, as per the submissions, the prosecutrix did not disclose the incident to anybody, neither friends nor family, and not even her husband ought of same. The ignorance as mentioned in the complaint. Stop. This version of the prosecutrix is against a natural conduct of the person. Stop. It would have been natural for the prosecutrix to disclose the incident to her family members after some time and not to somebody who is unknown to her, and as such it is very difficult to accept the version of the prosecutrix. Stop. We find it hard to believe that such a grave incident was not disclosed by the complainant even to her husband at any point, but was done so to a stranger woman who never deposed in front of the court. Stop. It is also to be observed that the whole case is based on the sole testimony of the prosecutrix, and no other witnesses or evidence has been produced. Stop. We are also of the view that the defense of prior enmity between the parties has also not been properly considered by the courts below, and complete weightage has been given to the testimony of the prosecutrix and her emotional outbursts. Stop. There also exists material inconsistencies in her statements that further weakens the case of the prosecution. Stop. The present case wholly depends upon the testimony of the prosecutrix. Stop. The incident in the present case took place 7 months prior to the date of lodging the complainant, as a realization dawned upon her that she has been subjected to rape by the appellant accused. Stop. No complaint of grievance was made either to the police or the parents prior thereto. Stop. The explanation for delay in lodging the FIR is that the appellant accused promised her to marry. Therefore, the FIR was not filed. Stop. In cases where the sole testimony of the prosecutrix is available, it is very dangerous to convict the accused, especially when the prosecutrix could venture to wait for 7 months for filing the FIR for rape. Stop. This leaves the accused totally defenseless. Stop. Had the prosecutrix lodged the complaint soon after the incident, there would have been some supporting evidence like the medical report or any other injury on the body of the prosecutrix so as to show the sign of rape. Stop. If the prosecutrix has willingly submitted herself to sexual intercourse and waited for 7 months for filing the FIR, it will be very hazardous to convict on such sole oral testimony. Stop. Moreover, no DNA test was conducted to find out whether the child was born out of the said incident of rape and that the appellant accused was responsible for the said child.